with his powerful brainwaves cradled in the warmth of reasoning. It's time for Johnny Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dread Show.
Is well-settled law in Florida, now again, got to be careful, this is Florida here, that the public figure status of a defamation claimant is a question of law to be determined by the court. In other words, the jury doesn't get to decide whether a person is a public figure or not. The court has to. Courts have recognized three categories of public figures: general purpose, limited purpose, and involuntary. Limited purpose public figures are those who voluntarily inject their views or are otherwise drawn by their conduct into a particular public controversy and are therefore treated as public figures when they sue about statements bearing on that controversy. To determine whether a person is a limited purpose public figure, a court typically considers 1. Whether one or more public controversies existed at the time of the alleged defamation. Now, what about Kyle here? Absolutely. The Kenosha shootings amount to the public controversy of which Kyle was immersed in. And number 2, whether the plaintiff played an important role in such a controversy, and Kyle obviously did. And 3, whether the publication or broadcast at issue was germane to the plaintiff's role in the controversy. Here, NBC's broadcast of the transcripts was germane to the Kenosha shootings. In Kyle's case, the statements made by these public figures are certainly germane to Kyle's shooting of Rosenbaum and all. A public controversy includes any topic upon which sizable segments of society have different, strongly held views, okay? And do we have different, strongly held views of the Kenosha shootings? Oh, yeah. Or a dispute that a reasonable person would expect to affect people beyond its immediate participants. In other words, would anybody care about what happened during the Kenosha shootings other than the people who were shot? Yes. Let's face it, it was huge news in China, okay? So obviously, a plaintiff is held to have played a sufficiently important role in such a controversy when he has either voluntarily injected himself into the debate that surrounds it in an attempt to influence its outcome, or he has been drawn into the controversy by his own voluntary actions. So it sounds to me like the latter part applies to Kyle Rittenhouse. He volunteered to go in and guard property. That doesn't mean he's to blame, okay? Based upon the undisputed facts as stated herein, this court finds as a matter of law that Zimmerman became a limited purpose public figure. He voluntarily injected his views into the public controversy surrounding race relations and public safety in Sanford and pursued a course of conduct that ultimately led to the death of Martin and the specific controversy surrounding it. Notice, it doesn't matter here who's to blame. At no point is the court making a statement that George Zimmerman purposely created the controversy, just like with Kyle Rittenhouse. And in fact, George Zimmerman's behavior and Kyle's behavior are very similar as far as these lawsuits go. Both of them volunteered to take action to protect public safety. Both of them had things happen to them that they could not have foreseen. Moreover, Zimmerman's shooting of Martin rendered him a public figure in the ensuing controversy. So the mere fact that Kyle shot these people means that he has become a public figure. So far, there seems to be very strong parallels between Kyle's case and Zimmerman's. Standard of review. Summary judgment. So what the defendants have asked is the court to issue a summary judgment. In other words, basically, there's no dispute as to what happened. We all know what the law is. Given that, go ahead and find in our favor and be done with it. Okay, so I'm not going to read this. It just talks about when you can ask for a summary judgment. Okay, defamation. In order to prove an action for defamation, a plaintiff must prove that the alleged defamatory statements were made. Okay, no problem there. That the alleged statements were false. Well, okay. I mean, you can claim that she's calling me a murderer and I was acquitted. That's not a really good, strong case, by the way, because the term murderer could be considered an opinion. All right. But let's just accept it at face value that Whoopi's calling of Kyle a murderer was, let's say, factually incorrect. That the alleged false statements were published to a third party, yes. Whoopi Goldberg just didn't keep this to herself. She broadcast it to the world. And that the alleged false statements resulted in damages. Okay, so far, we're okay, I think. A public figure bringing a defamation claim must also prove that the publisher acted with actual malice. And that's where things go haywire for George Zimmerman. This court has determined that Zimmerman is a public figure. And why? He inserted himself into a controversy by shooting somebody. Is Kyle Rittenhouse a public figure? Yeah, no doubt about it. Therefore, on summary judgment, Zimmerman must present record evidence sufficient to satisfy the court that a genuine issue of material fact exists which would allow a jury to find by clear and convincing evidence the existence of actual malice on the part of defendants. This is an issue in front of the jury. So, what kind of evidence is there that Whoopi Goldberg not only made claims about Kyle being a murderer, but also she did it with malice? Okay, so here is the Florida bar. They'll weigh in on what is malice here. Constitutional malice, also called actual malice, is the publishing of a defamatory statement either knowing it is false or with reckless disregard for its truth or falsity. Requiring a showing of constitutional malice for a public figure to sue for defamation or to impose greater than actual damages on the media is intended to prevent a chilling effect on news reporting and protect First Amendment rights. The concept of knowledge of falsity is familiar to all attorneys in multiple contexts. Recklessness as to falsity, however, has evolved definitions and inferences unique to defamation law. The Supreme Court articulated the parameters of reckless disregard in St. Amant versus Thompson. Reckless conduct is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. There must be evidence to permit the conclusion that the defendant in fact entertained serious doubts as to the truth of its publication. Therefore, according to what I read in the Florida Bar webpage, it's not enough for Kyle to show that Whoopi made a statement that he was a murderer. He would have to show that A, Whoopi Goldberg knew he was not, but said it anyway, or B, entertained serious doubts as to whether he was in fact a murderer, but said it anyway. Do we have such evidence? Okay, so it goes on here. Under the rational interpretation analysis of actual malice, which we just read, the Supreme Court has held that as a matter of law, actual malice may not be inferred simply from the falsity of a statement, as long as the statement represents a rational interpretation of an ambiguous source. All right, then we go to intentional infliction of emotional distress. In Florida, a plaintiff alleging IIED must show that A, the alleged wrongdoer's conduct was intentional or reckless. 2, the conduct was outrageous. 3, it caused emotional distress. And 4, the emotional distress was severe. Okay, so we go to conclusions of law. The court accepts the legal conclusions as set forth in defendant's motion for summary judgment. In this case, Zimmerman has alleged 2 counts against defendants based upon 5 alleged defamatory news broadcasts. In reviewing these broadcasts, it is necessary to analyze the challenged publications in its natural sense without a forced or strained construction. I'm not sure what they mean by that. The court must evaluate the entire broadcast, not just the discrete portions of that the plaintiff claims are defamatory. In his complaint, Zimmerman claims that in March 20, 2012, Today's Show broadcast defendants employed deceptive and exploitive manipulations of Zimmerman's own words to create the illusion of statements that Zimmerman never actually made. The Supreme Court in Masson v. New Yorker magazine held a deliberate alteration of the words uttered by a plaintiff does not equate with knowledge of falsity for purposes of, well, it looks like they left something out there. Unless the alteration results in a material change in the meaning conveyed by the statement. Now, you would think, well, it does. Leaving out the dispatcher's question changed the meaning of George Zimmerman's comment about Trayvon Martin being black. The court went on to explain that before a public figure may be permitted to pursue a defamation claim, the trial judge must first determine, as a threshold issue of law, whether the altered quotations as published carried the same gist or sting as the plaintiff's actual statements, regardless of the words used. Simply stated, if an author alters a speaker's words but affects no material change in meaning, including any meaning conveyed by the manner or fact of expression, the speaker suffers no injury to reputation that is commensable as defamation. The court concluded if every such alteration constituted the falsity required to prove actual malice, the practice of journalism, which the First Amendment standard is designed to protect, would require a radical change, one inconsistent with our precedents and First Amendment principles. Okay, now, this doesn't seem to be all that applicable to Kyle Rittenhouse. Whoopi Goldberg is not mangling something that Kyle Rittenhouse said, but notice something. The court is bending over backwards to protect journalism and the First Amendment, and I suspect that the courts will do the same regarding his lawsuit. I mean, if you can sue Whoopi Goldberg for calling him a murderer, does that not quelch a lot of First Amendment speech? I think that the court would rule that it does. It is undisputed that Zimmerman spoke the words attributed to him, and then he made the challenge statement about Martin's race with no prompting from the dispatcher. And they're referring to, he's got his hand in his waistband and he's a black male. A party's accurate quoting of another statement cannot defame the speaker's reputation, since the speaker is himself responsible for whatever harm the words might cause. Zimmerman cannot carry his burden of proving that the single allegedly defamatory statement he challenges in the March 20 Today Show broadcast was disseminated with actual malice. As the Supreme Court explained in Masson, defendants cannot be said to have published that statement despite a high degree of awareness of its probable falsity. Where, as here, its selection of excerpts from the non-emergency call for inclusion in its broadcast did not effect a material change in the meaning of what Zimmerman actually said. We have long held that actual malice requires material falsity. Zimmerman bases his claim that the March 20 nightly news broadcast defamed him, alleging that defendant Allen falsely reported during the non-emergency call that Zimmerman uttered a racial epithet. Zimmerman cannot meet his burden of proving that the use of the phrase racial epithet was false. First, Zimmerman denies that he used such an expression. Second, the FBI has concluded that it is impossible to verify what Zimmerman actually said due to weak signal level and poor recording quality. Based upon the undisputed facts, whether Zimmerman used a racial epithet cannot be verified as false. And as a result, he cannot, as a matter of law, carry his burden of proving material falsity. So what they're saying is that, yes, it may have been a really dirty thing that NBC did, but because Zimmerman can't prove that he didn't say a racial epithet, he can't show that they did anything wrong. Therefore, he has no claim. Moreover, Zimmerman, as a public figure, must prove actual malice, a heavy burden that requires him to demonstrate by clear and convincing evidence that, at the time, the defendants disseminated a challenged publication or broadcast. They realized that its statement was false or subjectively entertained serious doubt as to the truth. The question whether a plaintiff can carry his burden of proving actual malice is, as a threshold matter, an issue of law to be decided by the court. In applying the actual malice standard, the Supreme Court has identified certain recurring scenarios in which a plaintiff's allegations with respect to a defendant's conduct, even if credited, are insufficient as a matter of law to constitute the clear and convincing evidence necessary to support a finding of actual malice. One of those is the rational interpretation doctrine articulated by court in Pape and Bose. In this case, application of the rational interpretation doctrine precludes, as a matter of law, a finding that the March 20 nightly news broadcast description of the non-emergency call as containing a racial epithet was disseminated with actual malice. That is, with the requisite high degree of awareness that it was probably false. Okay, so let's go to Whoopi Goldberg. Can you show that she knew that her claim that he was a murderer was probably false, but said it anyway? The tape recording itself is, at best, ambiguous. Under such circumstances, the broadcast interpretation of that ambiguous portion of the recording, like Times' interpretation of the commission report and Pape and Consumer Union's interpretation of what its reviewers heard on the audio recording at issue in Bose, cannot support a finding of actual malice as a matter of law. Ultimately, in the end, if you say something and it's garbled, journalists can pretty well make up anything they want and broadcast it and say, it appears like he is saying such and such. Or they can even claim he's saying such and such. They have to be very careful. If they text to a friend that, yeah, I know that he's not saying that, but let's just say it anyway, that could land them in some trouble. However, without that kind of evidence, Kyle Rittenhouse is going to face a real hurdle here. Zimmerman claims that the March 19 WTVJ and March 22nd and 27th Today Show broadcasts falsely implied that he is a racist by omitting the dispatcher's question before playing and quoting his response. No one doubts that what NBC did there was really, really dirty. Okay? They even fired their producer over it. NBC knew that this was totally uncalled for. But can Zimmerman claim damages? Let's read on. The Supreme Court's analysis of two of the contested quotations at issue in Masson demonstrates why, under these undisputed circumstances, NBC's inclusion of the "he looks black" excerpt in these three broadcasts cannot be held as a matter of law to have effected a material change in the meaning of what Zimmerman actually said. Especially in the wake of the Supreme Court's analysis of the allegedly fabricated quotations at issue in Masson and the court's reaffirmation of that analysis in Air Wisconsin Airlines Corporation, Zimmerman cannot base a defamation claim on NBC's airing of his recorded statement that the man he was following looks black, when he volunteered precisely that same information at another point during a non-emergency call without prompting from the dispatcher. It is undisputed that Zimmerman volunteered to the dispatcher that the person he was following was a black male. The fact that his separate statement that the man looked black was preceded by a question which was not included in the broadcast, does not result in the kind of material falsity necessary to support a finding of actual malice as a matter of law. In other words, no. No matter what you think, and yes, it was dirty. It did change the perception of what George Zimmerman said. It doesn't matter. He has no basis for his lawsuit there. I mean, there's no question that what NBC did very much painted a different picture about what George Zimmerman was claiming in that telephone call, but it doesn't make any difference. As in Masson and Air Wisconsin Airlines Corporation, the excerpt from the non-emergency call quoted in NBC's broadcast accurately captured the gist and sting of what Zimmerman actually said and were not false in any material sense. As the Supreme Court explained in Masson, an edited quotation cannot be held to have been published or broadcast with actual malice unless the alteration would have a different effect on the mind of the reader. I would actually kind of claim that it did, but they're not buying it. Absent such a showing, the First Amendment protects such editorial decisions from defamation liability because, as the Supreme Court has also emphasized, editing is what editors are for, and editing is the selection and choice of material. In this case, because Zimmerman is unable to demonstrate that the editing choices at issue resulted in material false change in the meaning of what he actually said, he cannot pursue his defamation claims arising from those choices as a matter of law. So, are you getting the idea that these courts tend to be very pro-media? You have to have a very strong case before they're even going to allow you to even present it. In Florida, okay, now we talk about damages. Let's suppose that Kyle's got a great case. Let's suppose that he can somehow show that Whoopi Goldberg made her statements with actual malice. Can he claim damages? Well, let's read. In Florida, a defamation plaintiff not only must plead and prove actual injury, he must also demonstrate that the allegedly defamatory statements proximately caused that injury. In his complaint, Zimmerman contends that the 5 challenged broadcasts exposed him to public contempt, ridicule, hatred, and threats to his life, as well as to severe and permanent emotional distress, mental anguish, embarrassment, and humiliation. Now, let's talk about Whoopi Goldberg. Whoopi goes on there and says, I think he's a murderer. Or let's say that she said he's a murderer. Okay, what would be the effect on Kyle Rittenhouse? Would that have exposed him to public contempt, ridicule, hatred, and threats to his life? Well, I don't think anybody's threatening his life because of what Whoopi Goldberg said. I don't think anybody's threatening Kyle because of what Whoopi Goldberg said. Could somebody hate Kyle who would not have hated him before because of what Whoopi Goldberg said? And because of what she said, did Kyle suffer severe and permanent emotional distress, mental anguish, embarrassment, and humiliation? No, not really. I can't see that. He further alleges that as a result of the broadcasts, he has had to live in hiding and wear a bulletproof vest. Okay, let's read on. The undisputed evidence shows negative publicity was directed at Zimmerman by the Martin family's lawyer, by civil rights activists, and by a litany of news media entities well before the non-emergency call was released to the public and before NBC broadcast any of the news reports at issue. In other words, people had already formed opinions of George Zimmerman well before they heard anything from NBC. Now, let's go to the Whoopi Goldberg deal. By the time that Whoopi Goldberg called him a murderer, had people already formed hatred of Kyle? Had he already suffered death threats? He experienced death threats on day one. So The argument here is going to be Kyle was already trashed nationally by everyone before Whoopi ever said anything. Prior to any of the challenged broadcasts, multiple national news organizations had disseminated detailed accounts of the Martin family's contention that their unarmed son had been profiled and killed by Zimmerman because of his race. Public demonstrations were held demanding Zimmerman's arrest, and members of Congress called for a federal investigation of what they described as a hate crime. Keep in mind, they're describing what took place before NBC weighed in. Zimmerman and his family had received death threats and had gone into hiding long before any of the challenged broadcasts. Did that happen with Kyle? Absolutely. His father and friends therefore reached out to the media to make the case that he is not a racist. Did that happen with Kyle? Yes, his mother at that same time, and I would also argue his lawyer, Lynn Wood, or was it John Pierce? One of the two was also out there speaking on Kyle Rittenhouse's behalf. At that same time, Zimmerman had already told police that his doctor had diagnosed him as suffering from post-traumatic stress disorder. Guess what? During the trial, it was revealed that Kyle Rittenhouse was suffering from PTSD. Before Whoopi said anything, the question of whether allegedly tortious conduct was the but-for cause of a plaintiff's claimed injuries. In other words, I would be fine but for what you said about me. I would be able to walk the streets at night but for what you did. So, was the but-for cause of a plaintiff's claimed injuries can be resolved by the court as a matter of law where the facts are unequivocal, such as where the evidence supports no more than a single reasonable inference. And I'm not sure what they're saying there. Based upon the undisputed facts, this court finds that the challenged excerpts from and characterization of Zimmerman's statements during the non-emergency call could not have been the required but-for cause of Zimmerman's alleged injuries. Let me spell this thing out. Because Whoopi Goldberg weighed in after Kyle had already started receiving death threats and already become a pariah amongst the public, Whoopi's statements cannot be considered part of the but-for requirement for damages. Kyle cannot say, I'd be able to walk the streets at night, but for what you said about me, Whoopi. He cannot say, my reputation would be fine, but for what you said about me, Whoopi. Not going to happen. Intentional infliction of emotional distress. Zimmerman alleges in count 2 of the complaint that he is entitled to damages for IIED. As stated herein in Florida, a plaintiff alleging IIED must show that 1. The alleged wrongdoer's conduct was intentional or reckless. 2. The conduct was outrageous. 3. It caused emotional distress. And 4. The emotional distress was severe. The outrageousness of the alleged conduct is a threshold test for recovery. It is a legal question in the first instance for the court to decide as a matter of law. Under Florida law, liability for IIED will lie only where the conduct in question has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. I don't think that calling somebody a murderer who has already been called a murderer by everybody and who was actually tried for murder meets this test. In this case, where it is undisputed that multiple other news reports characterized and edited Zimmerman's statements in virtually the same manner as the challenged broadcast, those editorial judgments cannot be deemed outrageous as a matter of law. Guess what they're going to say with Kyle Rittenhouse? Whoopi Goldberg was not the only one calling you a murderer. There were thousands of people calling you a murderer. They're going to point to social media and tons of tweets. So how outrageous could her comment be when there are thousands of other people who made the same statement about you? Even if Zimmerman was able to make out a prima facie case of IIED, the Florida Supreme Court has foreclosed such claims, whereas here, the plaintiff has attempted to transform a defamation action into a claim for intentional infliction of emotional distress simply by characterizing the alleged defamatory statements as outrageous. So let me translate that for you. Kyle is going to sue for defamation. And there are certain criteria that you have to abide to win a defamation case. It's very tempting to also claim that Whoopi Goldberg's statements were outrageous so that you can claim IIED. However, as it's saying here, the courts frown on that kind of action. So just claiming somebody's comments were outrageous in an attempt to try to claim that they have inflicted emotional distress on you intentionally doesn't cut it very well. And it says here, an attempt to state a claim for intentional infliction of emotional distress based on the same publication as the defamation count must fail. So, based upon the foregoing, this court finds that there are no genuine issues of material fact upon which a reasonable jury could find that the defendants acted with actual malice, that there exists absolutely no clear and convincing evidence that defendants knew that the information published was false at the time it was published, or recklessly disregarded the truth or falsity of those statements at the time they were published, and that the IIED claim is based on the same broadcast at issues in the defamation claim and therefore not actionable as a matter of law. It is therefore ordered and adjudged that Allen, NBC, Luciano, and Burnside's motion for summary judgment as to both counts in the complaint is hereby granted. So, in other words, they threw out George Zimmerman's lawsuit. So all you guys out there thinking that Kyle is going to be raking in millions from suing LeBron James and Whoopi Goldberg, what do you think now? Like my video, subscribe to my channel.